Salutations to all our future judges. In this video, we are going to see the tips for success in civil judge main exam part 2, and in this video we are going to see what are the skills expected in the main exam for any judicial aspirant who is attending any judicial exam across India. Already part 1 has been published. Those who have not seen part 1, please watch part 1, then you can continue watching this part 2 so that you get the continuity of what has been stated. I have provided the link in the iCard. In addition to this, a video has been published on tips for translation, which is applicable practically for any judicial exam across India. In addition to this, a series of videos which contains 7 parts has already been published with respect to the preliminary exam, wherein the pattern analysis of questions has been dealt with. Those who have not seen that video, please watch the video. I provided the link of the playlist also in the iCard. On watching these videos, you'll get a clear idea as to how you should tackle the civil judge exam. Before venturing into the video, I request you to watch the video from the beginning till the end without skipping in between, because each and every aspect which has been dealt with is very important for any aspirant who is aspiring to become a civil judge. Let us have a small recap of what we saw in part 1 so that you could refresh your memory with that. First skill expected is a language capability, and it is a general capability which is expected from any candidate who's trying to become a judge. Next is the legal procedures. As you all know that there are 2 major codes which provide legal procedures. So what they expect is, they expect the judicial aspirant to have thorough knowledge of civil procedure code and criminal procedure code. As you all know, a person who has been selected either could be posted as a civil judge or as a magistrate, depending upon the situation and circumstances. So it is very much essential that you should have equal knowledge in civil as well as in criminal procedures. The third point is analysis, applicability or admissibility of evidence. So now you got the language capabilities. Now that legal procedure knowledge has also been acquired, the next aspect is how we should analyze or apply or check the admissibility of evidence. And the greatest help we can get in all these aspects is from Indian Evidence Act. Indian Evidence Act is common to both civil and criminal procedure code. So a judge needs to know as to when he should apply this Indian Evidence Act and what is the weight or the importance of an evidence. Fourth point is thorough knowledge on format. As you all know, any person or any advocate who is practicing will obviously know that each and every petition which is filed is in a fixed format, which is generally provided in various acts and codes. So it is essential that a judge should know whether the petition filed to him or whether an application given to him or any other document submitted to him is in order, is in a specified format. It is very important. Next is implication or knowledge of constitution. As you all know, Indian constitution is supreme, and any act which is done by a judge should be governed by the constitution. It should not violate the constitution. So it is essential that a judge should have an absolute knowledge on Indian constitution. Next is, if you are sitting as a judge, there are certain skills which are expected from a judge, and in main exam they test whether you have these skills as a judge. Of course, this is not only pertaining to the knowledge of law, this is also pertaining to the applicability of certain aspects. This includes judgment writing and framing of charges, bar issues. Now, coming to the legal procedure. So what they expect in legal procedure is you should have a proper understanding of the civil procedure code and criminal procedure code. And you should also know the proceedings which are followed in the court. Because it is not only the civil procedure code or the criminal procedure code which governs the functioning of a court. There are certain other aspects which also govern the functioning of the court in addition to the civil procedure code as well as the criminal procedure code. Each and every aspect needs to be known by the judge. Next is, there are certain order which is followed. For example, if there is a proceeding, if there is a case which needs to be conducted, there is a procedure in which it needs to be done. For example, the first aspect, when a complaint comes to the judge needs to see as to whether there is a prima facie in the case. If there is a prima facie, then the witnesses can be summoned, the accused can be questioned. So it goes in a procedural way, it goes in a particular format. So if that format is wrong, there is a possibility that the order given by the magistrate could be struck down by a higher judge. So it is very essential that a civil judge needs to know the order in which a proceeding is to be done. Next is, there are certain documents which are very much essential for determining or deciding a case. So a civil judge or a judge generally needs to know what are the documents which are required to come to a conclusion in a particular case. And what to do if those documents are not submitted, and what if those documents are not available. Each and everything has been elaborately provided in the legal procedure, particularly in the civil procedure code as well as in the criminal procedure code. In addition to this, certain rules of practice, criminal rules of practice or civil rules of practice are also provided. Of course, this would vary from state to state. However, there are certain rules which are provided. In addition to this, there may be certain acts which say that civil procedure code may not apply or criminal procedure code may not apply. They may have their own procedure, and each and everything is to be identified and recognized and memorized by the judge. Next, the acts connecting the facts with the legal procedure, if any. For example, there could be some acts which say like civil procedure code will apply in this particular section, whereas for other sections the civil procedure code may not apply. So there may be a variation. So the judge is expected to know how he should connect that act with the legal procedure, if any. It is very essential. Next is analysis, applicability and admissibility of evidence. To put it simply, each and every person who is trying to pursue his career as a civil judge needs to know Indian Evidence Act thoroughly. It is very essential that each and every person who is writing the main exam for the judicial exam, any judicial exam for that reason, it may be civil judge or a higher judicial service or even other competitive exams. So there could be questions on Indian Evidence Act, and in that what they expect is evidence is given to you. How do you identify or how you analyze and come to a conclusion that evidence which has been submitted to the court is valid? Or is there any evidence which needs to be submitted to the court which could validate or which could help in deciding the case? And the next is applicability of the evidence. Evidence has been given, whether the evidence can be applied to the fact in hand. And the third aspect is admissibility of that evidence. That also needs to be taken into consideration. Whether the evidence is admissible. There may be certain evidences which cannot be admitted. So a judge needs to know whether evidence which has been submitted to the court is first of all admissible or inadmissible. Next is, if evidence is given, then the judge needs to analyze the effectiveness of an evidence, whether that evidence is helpful in adjudicating the case effectively. Next is, as I already explained, the admissibility and inadmissibility of an evidence need to be identified. And the last and the very crucial thing is, evidence is given, facts have been stated, and various witnesses have been examined, cross-examination has happened, chief examination is over, and all the legal procedures have been completed. Now comes the major or the main role of the judge. He needs to identify and connect the evidence with the facts of the case. He's provided with all these aspects. Now, he needs to correlate the fact with the evidence and identify whether the fact which is stated is true, or benefit of doubt is available, or is there a possibility that it is a wrong case, or is there a requirement that it needs to be referred to a higher judge. All these aspects needs to be analyzed, and finally a decision is to be given based on this analysis what has been done by the judge. If you feel that the video was of some use to you, please do subscribe the channel by pressing the red color subscribe button and select all to receive the notification immediately when a video is published in this channel. And do remember to turn on the notification in your YouTube channel. Do share the video with your friends or to those who are in need. If you like the video, please do press the thumbs up button, and your comments are most welcome in this channel. If you feel that I've left something in this video, or if you feel I need to put a video on some other subject, please let me know by way of comment. All your comments will be attended to. I'll try to post a video on whatever subject you are asking. Let us join hands together and contribute for a learned society. Thank you.